Hello friends, in this video I am going to discuss Payment of Wages Act 1936. In the beginning, with the growth of different industries in India, problems related to payment of wages to persons employed in the industry augmented. As they were being exploited, the industrial units were making payment of wages to their workers at regular intervals. On the other hand, wages were also not uniform. The industrial workers were forced to raise their heads against their exploitation. This is how the Payment of Wages Act 1936 evolved. So let's understand the act with the first question, that is, who are eligible under this act? The Payment of Wages Act 1936 is enacted for the persons employed in any factory or employed upon any railway by a railway administration or either directly or through a subcontractor by a person fulfilling a contract with a railway administration, and also for the person employed in an industrial or other establishment. Now, the next question is, what is wage? Wage means all sorts of remuneration in any form, such as salary, allowances, bonus, or otherwise. Further, as expressed in terms of money or capable of being so expressed, which would, if the terms of employment expressed or implied were fulfilled, be payable to a person employed in respect of his employment or of work done in such employment. Now, the next question is, who is responsible for the payment of wages? Every employer shall be responsible for the payment of all wages required to be paid under this act to person employed by him and in case of persons employed. Now, the next question is, what is wage period for a payment of wages? According to this act, the person responsible for payment of the wages shall decide the wage period, but this period shall not exceed 1 month. Note, where the employment of any person is terminated by or on behalf of the employer, the wages earned by him shall be paid before the expiry of the second working day from the day on which his employment is terminated. But where the employment of any person is an establishment is terminated due to the closure of the establishment for any reason other than a weekly or other recognized holiday, the wages earned by him shall be paid before the expiry of the second day from the day on which his employment is so terminated. Now, the next question is, what are the conditions the employer can deduct the wages of his employee? According to this act, following are the conditions under which an employer can deduct the wages of his employee. Fines. The total amount of fine which may be imposed in any one wage period on any employed person shall not exceed an amount equal to 3% of the wages payable to him in respect of that wage period. Note, no fine shall be imposed on any employed person who is under the age of 15 years. Every fine shall be deemed to have been imposed on the day of the act or omission in respect of which it was imposed. No fine imposed on any employed person shall be recovered from him by installments or after the expiry of 90 days from the day on which it was imposed. Conditions continue. In case of absence of duty, so if any person is absent, employer can deduct his salary. Next, damage loss due to negligence. If any employee does something or ignores something that causes harm to the company, in such condition, employer can deduct. So, deduction for damage to or loss of goods expressly entrusted to the employed person for custody, or loss of money for which employee is accountable, where such damage or loss is directly attributable to his neglect. Next, in case house accommodation is provided. If employer provides some sort of house accommodation, in such a condition, he can deduct some amount from his salary. Next, in case a special amenities and services provided by the employer. The word services doesn't include the supply of tools and raw materials required for the purpose of employment. Next, in case advance payment or loan is given to the employee. Now, the next question is, what is the right of an employee? Under this act, wages are the right of an employee that employer cannot deduct, hold, or delay. Note, in case if any employer deducts, holds, or delays the wages of an employee without giving the substantial reason, the employee can take legal action against his employer. Next, payment in case of death of the employed person. If an employee dies during his service period and employer owes his wages of any form, then his amount should be paid to the person nominated by him. Note, however, if no such nomination has been made or where, for any reason, such amount cannot be added to the person nominated, be deposited with the prescribed authority. Last but not the least, that is tipping and service charge. Although this is not included in this act, but this is also essential for you people to know. That is, it was a sort of tradition to give tip or and service charge in restaurant and hotel. Surprisingly, such charges range from 5 to 20%. Considering the same point, Consumer Affairs Minister Ramvilas Paswan had cleared this point that service charge is completely discretionary, and should a customer be dissatisfied with the dining experience, he/she can have it waived off. Therefore, it is deemed to be accepted voluntarily. Hence, such charges cannot be imposed forcibly. So, this is all about the Payment of Wages Act 1936.